Welcome to the Rhijn Legal and Property Podcast, your trusted guide to real estate and legal solutions across borders.
Welcome to the Deep Dive, your shortcut to being well-informed. Today, we're tackling a topic that touches everyone, even if they haven't thought about it yet. What happens to your legacy after you're gone? Imagine you've built a life, acquired cherished possessions, maybe even a thriving business, and you want to ensure everything goes exactly where you intend. It sounds straightforward, right?
It does?
But the legal maze, especially when assets span different countries, well, it can be incredibly daunting.
It truly is a universal desire, that control over your legacy.
Yeah.
But as you've hinted, the reality is far more intricate. It's a fascinating blend, really, of ancient legal principles and modern, often surprising, practical workarounds.
Absolutely. And when we refer to the civil code today, we're talking about the GRF, or Gражdanský Kodex Rosyjskiej Federacji. That's Russia's foundational legal text governing all of this.
The bedrock, yeah.
Our mission today is to cut through all that legal jargon. We want to provide you with a clear, concise understanding of how inheritance works in Russia. You know, from the profound power of your personal will to the intricacies of cross-border planning.
Exactly. Our research delves deep into the specifics of the Civil Code, particularly Articles 1118 to 1182. We've also looked at methodological recommendations for notaries and some really insightful analytical articles on international estate planning.
Including those complex non-conflict clauses.
Yes, those often misunderstood clauses, too. We're here to give you those aha moments, basically, to make you feel truly well-informed.
Okay, let's unpack this then. Imagine you have, say, a treasured antique collection. You want to leave it to a distant cousin or maybe even a charity, completely bypassing your immediate family. Is that even possible under Russian law? Can your personal wishes truly dictate the future of your assets, or are there strict family hierarchies that, get in the way?
Well, what's fascinating here is Russian law's core principle of freedom of testament, Article 1119 of the Civil Code.
Freedom of testament. Okay.
It means you, as the person making the will, the testator, have broad discretion, really broad. You can bequeath property to any person.
Any person.
Yeah, whether they're a close family, a distant friend, doesn't matter. Or even a legal entity, the state, an international organization. You decide.
Wow.
You can determine the shares of your heirs as you see fit. And here's something key for many. You can even disinherit one, several, or all legal heirs without needing to state a reason.
Without giving a reason. That's quite powerful.
It is. It grants an incredible degree of autonomy. So theoretically, yes, you could leave absolutely everything to a stranger and exclude your own children.
And the law would uphold that. Are there any exceptions? We'll maybe touch on that later. But first, privacy. What about that? If I write a will, does everyone immediately know what's in it? Or even that I've written one?
That's a really important question for many people. And it's a critical protection in Russia. The secrecy of the will, Article 1123.
Secrecy of the will, okay.
You are absolutely not obliged to inform anyone, not your potential heirs, not your family, nobody, about the content, the creation, any changes, or even if you revoke it.
So it's completely confidential.
Totally. This secrecy is legally binding. Notaries, witnesses, anyone involved, they're legally bound to keep it confidential until the inheritance officially opens.
Which is after your passing.
Of course.
Yeah.
And violating that secrecy, it can lead to severe penalties. We're talking compensation for moral harm, maybe administrative, or even criminal liability for notaries.
That's a strong guarantee. So, okay, you've decided your wishes, you know they're secret. What's the actual process? How do you make that will legally binding in Russia? What are the rules and any interesting exceptions?
Right. So the general rule, the standard procedure, is that a will must be in written form and notarized. That's Article 1124.
Written and notarized, standard.
But the law provides for some really vital exceptions, situations where a notary just isn't available. In specific circumstances, other authorized officials can certify a will, and it gives it the same legal weight as a notarized one.
Like who?
Well, think chief doctors or their deputies in hospitals, captains of ships at sea, heads of, say, remote expeditions, military commanders in certain situations.
So practical exceptions for difficult circumstances.
Exactly. If you're a patient in a remote hospital, the chief doctor could certify your will. It's crucial flexibility for emergencies.
Okay, here's where it gets really interesting, though. What if the person making the will has a mental illness or maybe dementia? Can a doctor just refuse to certify their will based on that?
This is a crucial detail, and it's a bit of a fine line. Formally speaking, A refusal to certify just because of mental illness or dementia? That's only really permissible after a court has legally declared the person incapacitated.
Only after a court ruling.
Right. However, and this is the tricky part, if that will is later disputed in court, the court might still deem it invalid if it's proven the person wasn't capable of understanding their actions or controlling them when they made the will, even if they hadn't been formally declared incapacitated yet.
So capacity at the moment of signing is key, regardless of formal status.
Precisely. And you also need to watch out for pitfalls like having the will certified by the wrong person, a regular doctor instead of the chief doctor, for instance. That could unfortunately make it invalid. Precision is just paramount.
Got it. So beyond these standard notarized wills and these specific equivalents, are there any really unconventional ways or maybe more modern methods Russian law allows for expressing final wishes?
Absolutely. There are a couple of unique options. One is a closed will, Article 1126.
Do closed will.
Yeah, it's quite special because no one, not even the notary, knows what's inside.
Really? How does that work?
We have to handwrite it and personally sign it. Then you seal it in an envelope. That first envelope, it goes inside a second envelope, and that one is certified by the notary, but in the presence of 2 witnesses.
Okay.
Then, after your death, the notary opens it, usually within 15 days, in front of the witnesses and any interested parties.
Fascinating. But you mentioned limits?
Yes, important note. Closed wills can't be used for joint spousal wills or for setting up those hereditary foundations we might talk about later.
Okay. What else?
Then there are emergency wills, Article 1129. Think of a truly dire, life-threatening situation. You genuinely cannot reach a notary, like a real message in a bottle scenario.
Right. Like in the movies.
Kind of. In those circumstances, you can express your last will in simple written form. But again, it must be handwritten and signed by you in the presence of 2 witnesses.
That sounds like a vital option for extreme cases. Does it actually hold up legally? It seems fragile.
It can, yes.
Okay.
But it comes with significant hurdles. The key thing here, the document itself has to clearly state it's intended as a will.
Okay, intent must be clear.
Absolutely.
Yeah.
And crucially, it must be confirmed by a court later, at the request of interested parties or the witnesses themselves. And this has to happen within the inheritance acceptance period, usually 6 months.
So it needs judicial validation.
Exactly. You know, this rule caused a lot of debate when it was developed, potential for abuse, obviously, but ultimately it was seen as essential for those genuinely extreme cases where there was just no other option.
Makes sense. Okay, so we've covered creating a will, the formal ways, the exceptions. But what if, after all that, I just changed my mind? Is my will set in stone once it's made?
Not at all. You have the absolute right to revoke or amend your will at any time. Article 1130.
Yeah.
And you don't need to give reasons.
Total flexibility.
It's a core principle. You can do it by just creating a new will that automatically cancels out earlier contradictory bits. Or you can file a specific notarized statement saying you revoke it.
Simple enough.
But there's a key point here, a common pitfall. Let's say you make Will A, then Will B revokes Will A. But later, Will B is found invalid, or you revoke Will B itself.
Right.
Will A does not automatically spring back into effect.
Oh, interesting. So revocation is final for the older will, even if the newer one fails.
Exactly. You'd need to make a new will reflecting your current wishes. Always be precise.
That's really vital to know. Okay, what about more modern forms? You hinted at them. I've heard about joint spousal wills and something called hereditary foundations. Are these new options in Russia for more complex situations?
Yes, these are important, relatively recent innovations. They reflect evolving needs, definitely. Joint spousal wills, for instance, were introduced in 2018, Article 1118, Paragraph 4.
Okay, joint wills, how do they work?
They allow a married couple to make a single will together. It defines what happens to both their joint property and their individual property when either one or both pass away.
Both spouses need to be there for notarization.
Yes, both must be present. Often it's video recorded, too, unless they both explicitly object.
And can one person change it later?
Ah, interesting point. Yes, each spouse can unilaterally revoke or amend the joint will at any time, even after the other spouse has died.
Really? Even after one spouse is gone?
Yes. The notary must notify the other spouse if they make such a change while both are alive. Though, interestingly, if the notary fails to notify, the change is still valid.
Complex dynamics there. And the other one, hereditary foundations.
Right. Hereditary foundations, Articles 123.201 to 3. These came into effect more recently, 2022. This allows you to create a foundation through your will. It's designed to manage assets for specific beneficiaries or categories of people.
But not commercial companies.
Correct. Excludes commercial organizations.
So basically, it lets someone set up, via their will, a formal structure to manage assets long-term for beneficiaries. Kind of like a private family endowment, but under Russian law. Is that the gist?
That's a very good way to put it, yes. It's Russia's answer to a sophisticated asset management vehicle within estate planning.
Are there catches, complexities?
Oh, absolutely. The will itself must include the foundation's establishment decision, its charter, the management terms, all as inseparable parts.
So a lot of upfront legal work in the will itself.
Definitely. And these types of wills cannot be closed wills or emergency wills. They need full notarization. While they offer benefits like managed distribution, maybe tax advantages, there are complexities.
It says.
For instance, beneficiaries usually can't be the sole executive director. And if you fail to properly set up the governing bodies in the will, the foundation might not get created at all.
And the beneficiary's rights.
Crucially, the rights beneficiaries get from the foundation. They are not considered hereditary rights themselves, so they can't be passed on or transferred. It's a powerful tool, yes, but needs meticulous planning.
Understood. Okay, so that covers wills, but what if there's no will? Or maybe the will only covers part of the estate? How does inheritance work by law in Russia then?
Right, the default rules. In those situations, the law steps in with a very clear hierarchy. There are 7 queues of legal heirs.
7?
Yes. Heirs in a lower queue only inherit if there's absolutely no one in the preceding queues, or if everyone in the higher queues has been disinherited, refused the inheritance, or may be deemed unworthy.
Unworthy, what does that mean?
That usually involves specific illegal actions against the testator, like fraud or violence, aimed at increasing their own share.
Okay, so who's in the first queue? The most immediate heirs.
Exactly. The first queue, Article 1142, includes the closest relatives, children.
Biological children.
Yes, and also children conceived during the testator's life, but born alive after their death. Also the official spouse and the parents.
Official spouse, key word there again.
Crucial point. And adopted children and adopted parents are treated exactly the same as blood relatives for inheritance.
So a key insight here for many listeners might be who isn't in that first queue by default. We mentioned civil marriage or cohabitation.
Correct. Cohabiting partners, no matter how long-term, have no automatic spousal inheritance rights under Russian law if the marriage isn't officially registered. That's a huge potential blind spot.
Definitely something people need to be aware of. Are there any other crucial exceptions to these queues? You mentioned unworthy heirs. Anything else?
Yes, absolutely. There's a vital safety net for incapacitated dependents. Article 1148.
Incapacitated dependents. Who qualifies?
These are individuals who, regardless of their family relationship or which queue they might theoretically belong to, can inherit alongside the current queue inheriting if they were financially dependent on the testator for at least a year before death and are legally incapacitated.
And incapacitated means?
Typically minors or the elderly. The law defines this as 60 for men, 55 for women, or individuals with certified disabilities. It's an important provision ensuring vulnerable people aren't left unsupported.
That makes sense. Okay, moving beyond people, what about the actual property itself? Are there special rules for, say, unique assets or certain types of holdings that can complicate things?
Yes, absolutely. This is where it gets quite specific and frankly quite interesting. Take indivisible things. Article 133.
Indivisible things, like...
Think of items like a car, a valuable musical instrument, maybe a painting. Things that can't be physically divided without destroying their purpose or, significantly diminishing their value.
Right. You can't give half a violin to 2 different people.
Exactly. So if a will tries to divide such an item into physical parts for multiple heirs, the law basically ignores that instruction. It treats it as if the item is bequeathed in shares corresponding to the value of those intended parts.
Okay, so they inherit value shares, not physical parts.
Correct. And then the heirs have to agree on how to use it, or a court establishes rules. And here's a key insight. In a dispute, a court might award the whole item to one heir.
On what basis?
Usually if that heir has a significant interest in its use. Maybe it's related to their profession or needed for health reasons. But that heir would then have to compensate the other heirs financially for their shares.
Fair enough. What other special property types?
Well, there's property with limited circulation. Firearms are the classic example.
Ah, yes, guns.
If an heir inherits a weapon, but doesn't have the required license, they can't just keep it. They have a year. Either get the license or sell or transfer the weapon legally.
And if they don't?
Then the authorities will confiscate it for responsible storage. Interestingly, the notary doesn't demand the license up front when processing the inheritance. They just inform the heir of this rule. The license is for possession, not the act of inheriting itself.
A very specific rule, ensuring safety. Makes sense.
Then you have things like enterprises, Article 1178. Not just the business name, but the whole property complex, land, buildings, equipment, inventory, debts, intellectual property, everything.
Inheriting a whole functioning business.
Complex. Very. The law gives preferential rights to an heir who is already an entrepreneur or to a commercial organization. Heir to inherit the enterprise as a whole, again, with compensation to others.
And if there's no such heir?
Without that, it typically becomes shared ownership among the heirs, which, as you can imagine, can lead to huge operational challenges, maybe even financial difficulties if the heirs don't agree on how to run it or if some aren't interested.
Yeah, I can see that causing problems. Any others?
Agricultural land or farmers' holdings also have specific rules. Articles 1179, 1182. Things like minimum and maximum plot sizes. If dividing the land among heirs would violate these minimum size requirements.
It can't be divided.
Right. It might have to be inherited by one heir who has preferential rights, perhaps someone already involved in farming it, again with compensation paid to the others.
So lots of nuances depending on the type of asset. It's not just about value. Okay, we've talked about giving property. But can a will also impose duties, obligations on the heirs who receive the property?
Indeed it can. There are two main types of obligations you can place on heirs through a will. First is a testamentary refusal, also known as a legacy, Article 1137.
Testamentary refusal or legacy. What is it?
It's a specific property-related obligation. You impose it on an heir, could be an heir by will or by law, to benefit another specific person, who we call a legatee.
Can you give an example?
Sure. An heir might inherit a house, but the will says they must allow, say, the testator's elderly sibling to live in that house for the rest of their life or for a set period, or maybe provide them with regular payments from the inherited funds.
Okay. What if the heir sells the house? Does the obligation disappear?
Crucial point. No, the right follows the property. So even if the heir sells the house, the new owner is still legally bound by that legacy, that obligation, to let the sibling live there.
Wow, that's significant. How long does the legatee have to claim this right?
Generally 3 years from the date the inheritance opens.
Okay. And the second type of obligation?
That's a testamentary burden, sometimes called a bequest. Article 139. This is broader. It can involve property or non-property obligations, usually aimed at what the law calls a socially useful purpose.
Socially useful purpose? Like what?
Well, examples could be obliging an heir to donate a specific art collection to a museum, or to provide ongoing funds to a named charity, or, this is a fascinating one, obliging an heir to care for the testator's pets.
Caring for pets, that can be legally mandated in a will.
Absolutely. Animal welfare organizations could, in theory, even demand that the heir fulfills that duty if it's clearly stated in the will. Or perhaps an heir is obligated to maintain a family garden and keep it open for public viewing.
That's amazing. It really opens up possibilities for how a legacy can continue to have a specific impact. Okay, so you have these wishes, maybe obligations. What about someone to oversee it all, make sure it happens? Can I appoint an executor?
Yes, you absolutely can. You could appoint an executor of the will. The traditional Russian term is estona, which literally translates to something like sole executor, Article 1134.
Sole executor, I like that. Who can it be?
It can be an individual or even a legal entity, and they don't have to be an heir themselves.
Do they get paid?
They are reimbursed for all necessary expenses they incur, paid from the inheritance funds. But if you want them to receive additional compensation for their time and effort, you must explicitly state that in the will itself.
Okay. And they manage things?
Yes, they ensure the will is carried out according to your wishes, manage the estate assets during the process, and can even act as a trustee for inherited property if needed.
Got it. Now, a really common question, a big worry for heirs. What about debts? If the person who died left debts, do the heirs inherit those too? Could that put their own personal assets at risk?
This is a huge relief for many, actually. Heirs are indeed responsible for the testator's debts, Article 1175. But, and this is the critical limitation, their liability is strictly restricted to the value of the inherited property.
Okay, say that again. Limited to the value they inherit.
Exactly. Your own personal assets, your savings, your house, things you owned before the inheritance are completely protected.
So even if the debts are massive, far more than the assets inherited.
Even then, the creditors can only claim against the inherited assets up to their total value. The heir doesn't have to dip into their own pocket beyond that.
That's a crucial protection. What kind of debts are we talking about?
Generally, debts arising from contracts the testator made, loans, mortgages, unpaid bills, sales agreements. It typically doesn't include expenses related to the death itself, like funeral costs or paying for care during a final illness. Those are usually treated as separate charges against the estate before distribution.
Right. Okay. And finally, connecting back to our start, that freedom of testament. Is there any part of the inheritance that simply cannot be bypassed by a will, no matter what I write? Are there absolute limits to that freedom?
Yes. This is probably the most significant limitation we need to understand. It's called the mandatory share, Article 1149.
Mandatory share. Who gets it?
Certain categories of heirs are legally entitled to a share, regardless of what the will says. These are minor children of the testator or adult children who are incapacitated.
Incapacitated meaning disabled or unable to work.
Yes. Also, an incapacitated spouse, incapacitated parents, and certain other incapacitated dependents who relied on the testator.
And how much do they get?
They are entitled to inherit at least half of the share they would have received if there had been no will at all, if inheritance had proceeded purely by law.
Half of their intestate share.
Okay, so the will can reduce their share, but not eliminate it entirely if they fall into these categories.
Generally, yes. However, there's a nuance. Courts do have the power, in exceptional circumstances, to reduce this mandatory share or even deny it altogether.
And what grounds?
For example, if the mandatory heir is already extremely wealthy, and enforcing the mandatory share would be disproportionate or unjust compared to the heir named in the will, especially if the inherited asset was, say, the primary residence of the testamentary heir. It's about upholding a principle of social justice. So while freedom of testament is broad, it's definitely not absolute. The law protects vulnerable heirs. That's a really important balance. Okay, this has been a fantastic deep dive into Russian inheritance law itself, but what about the international angle? What if I have assets both in Russia and in other countries? This sounds incredibly complicated.
It really does, doesn't it?
Can I make one will that covers everything, everywhere? Maybe use one of those non-conflict clauses people talk about, saying, this will doesn't revoke my other wills. Does Russia recognize that? This is where global estate planning often hits serious snags.
And this is perhaps the most fascinating and definitely the most challenging area we've looked at. The straightforward, technical answer is, Russian inheritance law does not formally recognize non-conflict clauses or coexistence clauses, whatever you want to call them.
No formal recognition. So what does the law say?
Article 1130 of the Civil Code establishes a very strict temporal hierarchy. Basically, a subsequent will, one made later in time, automatically revokes any earlier wills, either entirely or in any part that contradicts the new will, even if the new will doesn't explicitly say it revokes the old one.
It just does so automatically by being later.
Exactly. It's a very precise, very strict statutory framework on that point.
So, hold on. If I make a new will in my home country, say the UK or the US, and I only intend it to cover my UK or US assets, that could accidentally invalidate my previous Russian will for my Russian assets, even if I didn't mean it to.
That is precisely the risk, a huge, often unintended risk, based on the strict letter of the law.
Wow. Okay. Is there any way around this statutory precision? How do people actually manage this in practice?
This is where it gets interesting, where judicial pragmatism comes into play. While the statute is strict, Russian courts, including the Supreme Court, have shown themselves to be, well, quite sophisticated. They often employ what you might call an intent-based interpretation when dealing with these international estate situations.
Intent-based, meaning they try to figure out what the person actually wanted.
Exactly. They often prioritize figuring out the testator's clear intentions, aiming to ensure a will is valid for the relevant assets, rather than just rigidly applying the temporal rule and potentially leaving assets subject to intestacy rules, inheritance by law, when there was clearly a will intended for them. They recognize people might legitimately have multiple wills for different jurisdictions.
Okay, so the workaround isn't some magic clause Russia formally accepts, but it's more about how you write the wills, making your intent absolutely crystal clear.
Precisely. That's the key. Professional practice in Russia for international clients strongly emphasizes a multiple will strategy, but using very careful asset-specific territorial drafting.
Asset-specific territorial drafting means
Meaning create separate distinct wills for different jurisdictions. For example, your will dealing with your Russian assets would state very explicitly, this rule applies only to assets located within the Russian Federation.
Okay, limiting its scope, clearly.
And crucially, you would add language like, this will does not revoke any other will previously made by me, or any will I may make in the future concerning assets located outside the Russian Federation.
Ah, so you explicitly state non-revocation of other wills, even though Russia doesn't have a formal non-conflict clause.
Exactly. By carefully identifying the assets, clearly limiting the territorial scope, and using that explicit non-revocation language concerning other jurisdictions, you create a kind of functional coexistence between the wills. It works in practice, even without formal doctrine supporting it. It's a powerful, practical workaround based on demonstrating clear intent.
That makes a lot of sense. Given all these complexities then, especially for international assets involving Russia, what are the absolute key practical steps? What's the bottom line for someone listening who's in this situation?
Strategic coordination, that's the phrase. It's absolutely vital.
Meaning?
It means starting early. Preparation is key. Engaging experienced international practitioners, lawyers familiar with all the relevant legal systems, Russia's and the other countries involved.
Get experts who talk to each other.
Yes. And meticulous documentation. Remember, foreign wills needed for Russian proceedings will require apostillation under the Hague Convention, plus a certified Russian translation. That process alone can take several months.
And time is tight.
Exactly. Remember, Russia's strict 6-month deadline for accepting inheritance after death.
Yeah.
You can't afford delays caused by paperwork problems. Timing is critical.
Any other tools?
Well, those newer domestic tools we discussed, like personal hereditary foundations and joint spousal wills. They also offer new avenues for coordination and planning, potentially simplifying things within the Russian part of the estate, even in an international context. More options than before.
Wow, what a journey. Okay, let's try and sum this up. We've really navigated the intricate landscape of Russian inheritance law today, from that profound freedom you have in crafting your will.
The freedom of testament.
To the critical importance of secrecy. We've uncovered the various forms your last wishes can take notarized, closed emergency wills. We looked at specific rules for unique assets like indivisible items or whole businesses.
And those obligations, legacies, and burdens.
Right, how they can shape your legacy. And maybe most importantly, for many, we learned about the surprising judicial flexibility and those practical workarounds for international estates, despite the formally strict rules about later wills revoking earlier ones.
It truly highlights something important, I think. While the legal framework is precise and can seem rigid on the surface, careful planning, really clear articulation of your wishes in the documents, and a nuanced understanding of these rules that can genuinely ensure your legacy is handled exactly as you intend.
So it's about using the tools correctly.
Exactly. Leveraging the available tools and employing strategic thinking within what is undeniably a dynamic legal environment.
So what does this all mean for you, our listener? Given these fascinating nuances, the power you have, the limitations like the mandatory share, and the practical workarounds we've explored, what aspects of your own estate planning might warrant a second look after hearing this? And maybe a final thought. How much is that true freedom of testament, backed up by meticulous planning to make sure it actually works? How much is that really worth to you?
That's something to ponder, definitely, as you consider your own legacy.